Hey guys, can you seize obvious contraband or evidence while executing a search warrant for a completely unrelated issue? This question comes from an officer in Texas. Guys, my name is Anthony Bandiero, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you the roadside chat from Iowa. All right, so the officer says, hey, look, um, detectives obtain a search warrant of a residence. They find evidence of a sexual assault. To find evidence of a sexual assault. Um, and during the search, they came upon marijuana and cocaine. Is a second warrant needed for those items, or can we, since they're obvious contraband, are we good to go? The answer is you're good to go. But since we're here, let's talk about a couple rules. Number one, this is a classic plain view seizure doctrine. In order to seize something under plain view, you have to have three elements. Number one is you have to be rightfully present. Right to be, right to see, right? If you have a right to be where you're at, you have a right to see, hear, and smell, right? Use your basically God-given senses. But the only one that gets a little touchy on your God-given senses is touch, which is the next element. You cannot manipulate the item, right? So if you're searching under the search warrant and you think that it could be evidence of the crime for the search warrant, then of course you can inspect it. But if you know it's not, something related to the search warrant, then the probable cause has to be immediately apparent, right? Looking at it, you're like, okay, I can tell that is, cocaine or stolen property or insert the blank. We get that idea that you cannot manipulate things from a case called Arizona versus Hicks. Might be Hicks versus Arizona, but either way, what happened there is police officers moved a stereo to see a serial number during an investigation of a shooting, suspecting that the stereo was stolen. No probable cause, but just having a pretty solid hunch. They moved it. They ran the serial number. Yes, it was stolen, and that evidence was ultimately suppressed by Supreme Court because that's not plain view, right? Manipulation. So, lawfully present, check. Do not manipulate the evidence, check. The third one for seizure is you have lawful access. What we are saying here is, do you have to make another constitutional entry or intrusion in order to seize the evidence? I'll give you a great example. You're in an apartment complex. You walk by a window and you see a brick of cocaine on the kitchen table. We can call that open view or plain view, but most cops are going to call it plain view. And I'm with you, right? I'm sold. That's plain view, right? You're lawfully present on the sidewalk. You're looking in there. You see something that's immediately apparent as contraband, plain view. But what you don't have is plain view seizure, because in that fact pattern, I gave you no exigency. There's just no way to get into that guy's house under those facts. You have to go secure it, keep people out. But let's change the facts a little bit. You see the brick of cocaine, and the guy comes out of the bathroom, he sees you, and he knows the jig is up. So then he grabs the brick of cocaine and runs towards the bathroom, apparently to flush it down the toilet. Can you enter? Yes. Why? Eminent destruction of evidence. Is that a plain view seizure? No, because you still don't have. You still have to make another constitutional entry, intrusion. You're going to be okay under a different doctrine, eminent destruction of evidence, but it's still not going to be a plain view seizure. Okay, one last fact pattern. You're responding to a domestic violence, or family violence in Texas, and you're there talking to the husband. You look over and you see a brick of cocaine on the end table near the couch. Plain view. Lawfully present? Check. Did you manipulate the evidence? No. Is it immediately apparent without manipulation? Check. Do you have lawful access? Absolutely. You're already in the house. You don't need to make another constitutional entry. Anthony, what if it's in the back bedroom and I can see it? It's still, you're going to be fine, right? Because you're already in the house. The intrusion has already been made for a lawful reason. So that is plain view seizure. And the final thing I guess I want to say to you is that if you now seek to search for narcotics, if you're like, okay, now the sexual assault, we have evidence, we're looking for that. We also want to look for narcotics, and we want to look into places that we would not normally get into under the sexual assault case. Then you're going to need what's called a piggyback warrant. You're going to have to go back to the magistrate, get another warrant to search for, to broaden the scope of search of the original warrant. Do you need a warrant at all for the contraband in Plainview? No, you can grab and go. All right. If you want to write us over at Blue to Gold and help you learn search and seizure and so forth, you want me to answer your questions in this type of format, go to bluetogold.com/show. Ask your question. If I can answer it, I stick to search and seizure issues here, not statutory legal interpretations and so forth. All right.